Thank you, sir, for allowing me to move this special motion that this House do now discuss the increasing alienation of tribal land in the state. Sir, this is a very important issue, and in fact, the problem that the people are facing in view of the increasing land alienation is quite alarming. So before I proceed with my submission, I would like to, for the benefit of this August House, reminded what land means to the tribal indigenous people. So for indigenous people, land is life, and not only livelihood. You take away our land, you erase our history, culture, and future. Land to the indigenous people is not a commodity to be sold, but a heritage to be protected. Land for the indigenous people is not merely an economic asset, so it is identity, dignity, and existence. Land for the tribal people is not just soil. It is sovereignty at the grassroots level. It is a sacred inheritance passing down through generations. So it sustains not only livelihood, but also tradition, custom, social security, and communal harmony. Therefore, sir, if we fail to protect it, we fail our ancestors. We betray the future generation. So today I stand here not only to speak, but to sound a warning. So the framers of the Constitution of India, in their wisdom, placed tribal areas under the protective framework of the sixth schedule, precisely because they understood that tribal land cannot be governed by market forces. So under Article 244(2), the Constitution of India and the provisions of the sixth schedule were granted us special constitutional protection because the framers of the Constitution recognized that tribal land is unique. So the sixth schedule was not charity. It was a constitutional shield. It empowers the district council to regulate allotment and occupation of land, management of unreserved forests, control over shifting cultivation, protection of customary laws. And so this is not symbolic autonomy. It is a substantive constitutional power. So therefore, sir, land is not for sale. It is our constitutional rights. So if despite these protections, community land is vanishing, then we must ask, where is the enforcement? Where is the political will? And where is the accountability? Today, what do we see? We are witnessing community land being fragmented. Powerful individuals capturing common resources. Traditional institutions weakened or bypassed. Increasing alienation of community land. So weak documentation and lack of transparency in Right, Ilika, and Hima lands. Encroachment and concentration of land in the hands of a few, and erosion of traditional safeguards. So development must not come as a cover for land capture. Investment must not become an excuse for this possession. So, in Garo Hills, land is broadly classified into three categories. Firstly, the rekinti or private and individual land. Secondly, rewrite, which is a community land. And thirdly, rikur, which is a clan land. So among the Khasi community, the traditional landholding system itself reflects this philosophy, and that is, no Khasi is meant to be landless. This system ensured social equality. It granted that every individual, even in death, would have a rightful place in the community burial ground, such as Kalom Jingtep Raj. So this is not merely land administration. This is social justice embedded in tradition. It reflects the sacred and collective ownership of land. And it is the depth and civilizational respect for land. So, sir, if community land disappears, then our constitutional autonomy becomes hollow. If right land weakens, the foundation of our traditional governance weakens. Again, development cannot come at the cost of dispossession, sir. Progress cannot mean erasure of identity. Growth cannot justify cultural extinction. So today, we are witnessing a deeply worrying trend. The increasing alienation of tribal land. This alienation is not confined to transfer to non-tribal only. More dangerously, community lands, which is right land, Ilaka land, and Himalayan, are gradually slipping away from the very communities they are meant to belong. It is encroached upon, manipulated, or concentrated in the hands of few powerful individuals. So therefore, sir, it undermines the very spirit of our customary system. And that is internal colonization. So this is not development. This is dispossession by design. So the emerging pattern resembles organized exploitation, where influential groups take advantages of legal loopholes, administrative silence, or weak enforcement. So therefore, sir, I feel if the state remains passive, history will judge us harshly. So, sir, there is also a connivance among people in power, district council, traditional heads, officials in the Deputy Commissioner Office, Revenue Department. So, sir, if we allow right land, Himalayan, Ilika land, sir, to disappear silently, then the sixth schedule becomes meaningless. It becomes a decorative provision in the Constitution rather than living protection, sir. The Constitution has already given us power. Failure to use that power is not helplessness, it is negligence. So therefore, it results, number one, sir, weakening of traditional institution. Number two, loss of collective ownership. Number three, rise of inequality within tribal society. Four, conflict between communities and authorities. So a case in point, land in Right Tendring, community land in Right Marwet, community land in Daistong, community land in Lumbangla, and many more, sir. So therefore, sir, I feel this is a very important issue that the House need not only to discuss, to take a very strong step. So as far as Garo Hills is concerned, it has come to my knowledge that Garo Hills is no exception either. The situation is further exacerbated due to the adaptation of the ALRR 1886 by the GHEDC. This has resulted in the conflict between the customary practices and the Assam Land and Revenue Regulation 1886, which was adopted and enforced by the GHEDC in the plained areas of Garo Hills. So in the case of Garo Hills, sir, land has been classified into two categories. Firstly, the hilly lands, and secondly, the plain lands. The hilly lands are controlled and managed by the customary beliefs and practices of the Garo community, whereas the plain lands are governed by the provision of the Assam Land Revenue Regulation Act of 1886, adopted by the Garo Hills District Council since its inception. So the hilly land is known also as the Aking land or the Clan land. The concept of Aking tenure is based on the inalienable and complete rights of the Aking chief or the Nokma with the members of the Chra and Mahari to act as custodian and guardian of the land. So it is found that the traditional land tenure system provides land to all members of the community, and this has, as I've been told, has knit them together, sir. So the sale of community land is not allowed. An individual household would use the land according to their need or as per the Jam cycle. So a distinctive feature of the traditional communal land tenure system is the role of the community in controlling and managing land, particularly for shifting cultivation. So the management of Aking land is done by the Nokma. He is the leader of the clan and acts as the manager. The Nokma does not enjoy the right of ownership and cannot inherit property since the Garo society is matrilineal. So the members of the clan can use Aking land without paying any rent. And a Garo from another Aking land does not enjoy the same right. It is an Aking specific right of land use. So, and there are some changes in the land tenure system of Garo Hills. The Aking land, which were traditionally used for jam cultivation, but after the Indian independence, the GHEDC introduced the Garo Hills District Awil Fees Act 1960 for regulating and assessing the collection of Aking land fees. Timber extraction and all other forests produced are regulated by this act. Accordingly, the arrangement was made that the Nokma collect 25% and the rest, 75%, is accredited to the council. So, sir, the changes in control, management, and use of the Aking land have accentuated and contributed to conflict among members of the traditional institutions of Garo tribe. The new situation in and around Tura has also created confusion about the right and duties of the elders of the owner lineage, and also about the power and function of the Nokma, sir. Now, many disputes have arisen between the Nokma and the elder of the owner lineage about the appropriation of compensation amount. Further dispute have also arisen to whose consent the Nokma should take to dispose of the land. Meanwhile, sir, more and more land is being acquired by migrant families and also by the government, and a sizable portion of the territorial possession of the lineage has now gone out of its possession, sir. The factors are causing a change in the concept of land holding among the Garos and a deviation from the traditional pattern. So, sir, the changes in the customary practices of acquiring land are because of various other factors that operate concurrently. Firstly, sir, a sharp shift from jhum cultivation to permanent cultivation. Lands are acquired by reclamation from the jungle or by transfer from the previous owner. The Garo Hills Autonomous District Council is issuing annual partas through which the parta holders are becoming owners of that land. This is a shift from the traditional practice of land control and management in Garo Hills. There are some cases where migrants, non-tribals, are occupying lands with legitimate partas issued by the district council. This gives them the right of ownership over the land. So families and individuals are transferring land by selling it off. In some cases, land is gifted. Also, mortgaging of acquiring land was noticed. So, as we are all aware, the state of Meghalaya has almost all in its entire territory under the 6th schedule. To discuss land management, land in Meghalaya was traditionally managed under the tribal land management system, where tribal individuals and communities own most of the land. So though the state government had enacted the Meghalaya Transfer of Land Regulation Act 1972, but with amendments made from time to time, there were provisions where a leeway is being provided to circumvent the law and to pave way for the alienation of land in our state. So, when we talk about landlessness in Meghalaya, we all knew, and I had even raised in this August House, as per the report of the Socio-Economic Census 2011, sir, Meghalaya has the highest landless households, especially in rural areas. Only 24% of the household in Meghalaya has land, possess land, sir. So, sir, tribal people in Meghalaya are increasingly become landless and poor as their traditional farming practices are abandoned in favor of commercial plantation. Much of the land, which has traditionally been owned and managed by tribal communities and clans without formal tenure titles, sir. Causes of landlessness are, as I've mentioned earlier, sir. One is the transfer of land. Secondly, privatization of communal land, land alienation, and developmental projects. The Assam Land and Revenue Regulation Act, ALRR 1886, is applied in Garo Hills through the adaptation primarily via the Garo Hills Autonomous District Land Revenue Regulation 1954. And the key issues and conflict with traditional land tenure, legal disputes over patas, cancellation and difficulties in implementing statutory regulation over often community managed land. So, the problems and the conflicts, especially in the context of Garo Hills, are as follows, sir. First one is a conflict with traditional land tenure, a king system. Let me first speak about the problem and the resulting conflict, sir. The Garo Hills function under the Aking land system, where land is owned by the clan Aking and administered by Nokma, as I've mentioned earlier, sir. Whereas the 1886 regulation assumes state's ownership of wasteland and seeks to create individual parta holders, sir. So the conflict is when the GHADC grants partas land deeds under the 1886 regulation, it often overrides the authority of the Nokma, as the regulation does not fully recognize the traditional communal land ownership structure. Number two, sir, legal discrepancy in land administration. The problem, while the 1886 regulation was adopted by Meghalaya, its application in the 6 scheduled areas is meant to be overseen by the Autonomous District Council. The conflict, there is a clash between the power of the state government on the 1886 Act and the GHADC owns regulation. For example, the Meghalaya High Court had noted that the GHADC has in the past issued land documents without proper consensus, creating legal ambiguity. So, the problem number 3 is the issues with land transfer restriction. The ALRR 1886, particularly Chapter 10, added in 1947, was designed to create protected belt and blocks to prevent non-tribals from acquiring land. Despite these provisions, there are constant allegations of illegal sale of land to non-tribal in areas under the GHADC, including the B Mahal areas. The enforcement of the 1886 regulation has not fully prevented such illegal transfer. Number 4, the GHADC has the power to manage land, but it often operates within the framework of the Assam Land Revenue Regulation 1886, which is the state-level act. And the result is this creates a conflict of jurisdiction, leading to litigation where the High Court has to determine whether the GHADC or the Deputy Commissioner has the final authority to grant or revoke a parta land deed. So, number 5, challenges to revenue collection and land valuation. The problem, the 1886 regulation, sir, is designed for systematic revenue collection. However, in the Garo Hills District Council, the land records are often not systematic maintained. So, the conflict is dispute arise between the GHADC attempts to fix land revenue rates or compensate for land acquired for developments, as traditional land has no fix with its value in the same which was surveyed privately owned land, sir. So the Guwahati High Court and Meghalaya High Court have noted that while the 1886 regulation is applicable in the state of Meghalaya, its provision must be interpreted in light of the power of the District Council under the 6th Schedule. So the exploitation of the system, the parta system, when imposed on traditional communal land, is sometimes used by powerful actors to acquire land that was meant for the community. So the result is that it had led to protests and legal challenges, sir. So, sir, and this statement which I've made here is also vindicated by the RTI report, which was asked by an MDC from Tura. And in his query, sir, he has clearly asked few questions which is relevant with this issue, sir. The first question which he asked on the RTI is that kindly furnish complete information when Assam schedule was introduced in JHEDC. Who introduced this to issue pata in JHEDC area? Kindly enclose copy of the Assam schedule. The reply is records not available, sir. So, sir, the RTI replies speak volume of the fact that there are two authorities. There is a conflict of authorities in as far as the management of communal land is concerned in Garo Hills. Historically and constitutionally, there were only 4 Moses in Garo Hills district, but I was told that the number of Moses, this revenue land, has increased to 10. And now in Garo Hills, the situation is such that the deputy commissioner is issuing pata, whereas they themselves don't have a pata for their own structure, for their own buildings. So I feel that time has come for our state to come out with a very strong mechanism to ensure that community land must be protected at any cost. Coming to Jaintia Hills. Jaintia Hills, though they adopted this Assam Land Revenue Regulation 1886, but it has not been directly adopted as the primary land law in Jaintia Hills. But its principles were adopted through the United Khasi Jaintia Hills District Land Revenue Regulation 1953. The 1953 regulation adopted the 1886 regulation to suit the local context, meaning it is not a direct blanket application, but rather an adapted version controlled by the Jaintia Hills Autonomous District Council. In summary, sir, the 1886 regulation serves as the foundational framework, but its application in Jaintia Hills is managed through the local 1953 regulation frame by the District Council, not like in the case of Garo Hills Autonomous District Council. So, we also know that indigenous people, the Panar of Jaintia Hills too, have deep connection with land and the nature around them. Very often, sir, when we speak about land grabbing, we tend to think that this is a story of outsiders who grab the land of the indigenous people for their selfish interests, and the case in point are the cement industries in the Narco area. Or it could be also, sir, be a case where a government, be it central or state government, taking over the land of the local people for what they deem to be for the benefit and interest of the people, as happened in New Shillong area. But land grabbing, sir, in Meghalaya also happen in a subtle ways, and in some cases by manipulating the traditional land holding system, which enable clan which are supposed to be mere custodians of the land to claim ownership over the community land. So ownership of land changes hands from the poor and the marginalized section of the society to the elite of the society. It happens in cases where rich coal miners bought the land belonging to poor people, and in some cases when the community forest is sold for a song, sir. So commodification of land, which has for a long been considered as a resource by our ancestors, is happening in the mining areas, and land is becoming scarcer by day, sir. So land which by tradition is considered a common resource is now being commodified. And land ownership is concentrated, as I've said, only among few powerful individuals. The change has not made only many families in the villages landless, but it has also created a division in the community where landless section of society are dependent. So therefore, sir, let this house not be remembered as mere spectator while community land disappear under our watch, sir. Sir, I feel we need and we must immediately, as a responsible government, conduct a statewide audit of all community and customary lands. Digitize and scientifically map Raj, Hima, Ilaka, communal land to prevent illegal transfer. Thirdly, sir, establish a transparent land registry mechanism in order to coordinate and also to coordinate with the Autonomous District Council. So, mandate prior informed consent of affected communities before any acquisition, lease, or change of land use. So, strengthen legal safeguard against misuse of customary authorities for private enrichment. We also need to place an annual report before this House on the status of tribal land protection. We must also bring transparency in land transaction involving customary institutions. So, we were elected to protect our people, not to preside over their dispossessions. So, I urge, therefore, this August House to send a very clear message that Meghalaya will not allow the erosion of its community land and customary safeguards under any circumstances. So, the continued alienation of tribal lands has not only disrupted the traditional ownership pattern, but has also triggered steep escalation in land prices, pushing many poor families into landlessness and economic vulnerability. So with these few words, I wish you my seat.